You're listening to the Vacation Rental Key with T&T, the podcast for vacation rental managers by vacation rental managers. I'm Tim Cafferty, and I manage two companies, one in Virginia and one in North Carolina. And I'm one of the two T's.
And I'm the other T, Tiffany Edwards, born and raised in the vacation rental business. I help manage our family businesses from Key West all the way to Kauai.
In the next 30 minutes, we're going to give you our keys to success in the vacation rental business. And we're back in spite of those of you looking on YouTube and see my dark apparel. Spring is coming. March is upon us. By the way, it's a logoed apparel for those of you looking here. We are glad to be here. I'm Tim.
I'm Tiffany. And this is our second attempt of being here. So our Wi-Fi is back up and we are ready. And second time is a charm. And we've got some great content for you today.
We do. I wasn't going to say anything about that. We tried to record earlier, but we had some gremlins that got in our way. And we are here today to talk to you, if you haven't already seen the episode title, about owner contracts. And so I need to put a disclaimer. For those of you that listen to the radio in the car, you may have heard a guy named Chuck McDowell. Sounds like somebody punched him in the throat. And he talks about timeshare. He's the timeshare cancellation guy. And he says, I want to set the record straight. I am not an attorney. I never wanted to be an attorney. And the truth is, I really don't even like attorneys. Well, if I sound like an attorney or I look like an attorney, I apologize. So that is our disclaimer as we get into this. We are not attorneys. So please consult your attorney before you change your management agreement. But you've got years of experience talking to you over the next 25 minutes.
Yeah, that is so on point, Tim. And I'm glad that you brought it up because that is a commercial that plays in my head all of the time. And I hope that you all will really connect the dots that we are not attorneys. But when Tim and I were preparing for this episode, we kept thinking about what are the items that are just absolutely non-negotiables. But before we even get started, your non-negotiables should be consulting with an attorney before you actually have drafted this and sent it out to anyone. You also need to make sure that your language is inclusive of your state statutes and your local ordinances. So there are some requirements, a lot of times locally, of insurance coverage, or if you have to have a broker that has to sign and guided under the real estate commission. And most importantly, if y'all don't remember anything, remember that every page needs to be signed. I can't tell you, unfortunately, how many times I've gone back to rental management agreements and there's been a page that's been missed, or someone just put it in the system and they didn't, they filed away the paper copy with the actual signature, but it's not in the computer system. Make sure all of that is intact.
Great. We have 6 points that we want to cover today. I'll say 6-ish because we always tend to veer off to a couple of other avenues. But these are points that I hope you have a pencil and paper ready. You won't need the eraser, but you will need all the lead in that pencil here in this episode as we have these areas covered. And experience talking. I don't know about you. I was looking the other day. I think I have 29 clauses in my contract, and every one has a story. Do you know how many you have in yours, Tiffany?
No, and I am now fearful to go back and look at how many clauses. And clauses, not addendums, my friend, clauses.
Exactly. So item number 1 we have on our list of 6 is to outline the responsibilities. That's what the agreement's all about, right? I had a famous member of the vacation rental community come to me years ago, and we had an agreement between the two of us. And he said, Tim, that's why we have agreements. So we know what you're responsible for, and we know what I'm responsible for. And in this case, what you're responsible for as the manager and what the owner is responsible for as the innkeeper, if you will.
Yeah, absolutely. And I think that this is really important that this responsibility stays consistent. So when you have your owner development team going and meeting with your owners, these talking points are usually discussed, but they have to be in that agreement. You have to have pen to paper and outline. Most importantly for me, Tim, I like to make sure that there is something listed about the use of the property and an understanding of how often the owner is going to use that property. So if you have some parameters around there, but also the notification of when they're using the property to alert and making sure that they honor those bookings. Those are some things that we don't necessarily remember, but they need to be outlined in your rental management agreement.
I think we all have stories about that where the owner comes back to you if you're like a summer destination and they come back to you in April and say, I noticed I got a booking for July the 4th. You know, I always use that week. Oh my. Yeah, honoring the bookings and making sure there's notification. Of course, you're going to notify them, but they notify you as well for owner use time. Make sure that's in there. How about when a property goes for sale? We went through a lot of that in COVID, right? The prices went up. People said, I'm getting out. And you had to deal with the transfer of the property, making sure you have something in there that the new buyer will honor the bookings. In some states, North Carolina, for instance, it is a requirement of law. And what happens if they have to be transferred? I'm sure you've had some experience there.
Yeah, we have. And in some of our agreements, not all of them, we have it listed where the owners have to help cover the costs if we have to move them or what those unintended consequences or costs are. So we have it outlined, but this is a non-negotiable for us because these properties do sell and you need to be consistent in how your team manages this process.
Onboarding costs, you're going to put that in there. If there's anything that you're going to charge the new owner coming on board, make sure that's clear and understandable. And then I also think when you're talking about the responsibilities, you have a section that says owner responsibilities. You'll provide a fit and habitable premises. That's the term in North Carolina they use with the Real Estate Commission. We're not quite sure what fit and habitable means. I know it when I see it, but making sure that's outlined, cost of repairs, making sure they're going to pay their utilities. I mean, all these kinds of things that come with experience, you put it in the agreement. And then, oh, by the way, what are you going to do? How are you going to market the property? When are you going to pay the owner? What kind of services are you going to offer? Maybe even outline what your cleaning looks like. That you're going to do a broom clean. You're not going to do the chandeliers every week or whatever. I can hear some of you go, and this agreement's going to be 42 pages. Well, maybe so, but I'm telling you, these things need to be in there.
That's how you get to those 29 clauses. But that responsibility is really important, and payment expectations on or before this date. Managing expectations is really important, and having it outlined as simple as possible of their responsibilities, your responsibilities, and even if it doesn't have a number amount to it, who is responsible for payment for, those different programs, say a linen program. Got to make sure that you have that outlined.
The other thing I throw in here as well, I know there are some states that have specific exclusions to this, but make sure the agreement says on it that it is an exclusive right to rent the property, not an open agreement, where I think New York, for instance, has an open agreement. Nobody has an exclusive agreement, but you are the agent. So no matter who rents it, Mr. Owner or guy down the street, you are due your commission because you were the exclusive agent. Pro tip there.
Yeah, absolutely. Underline, highlight, exclusivity, major exclamation point. And Tim, to go back to, because you made the mention of habitable, your attorney will direct you on this, but I find that anytime that you can reference actual state statute or your local ordinance language, you're doing much better in mimicking that language instead of creating your own terminology.
Don't want to gloss over that. There's a lot under responsibilities. I'm sure you guys think of some right now. And let us know, by the way. Hit us up. We have a Gmail address, thevacationrentalkey@gmail.com. or any of our social accounts. If we missed something, we're glad to come back and talk to you about it in another episode. Number 2 on our list would be what's most important to all of us operators. That's how we're going to get paid. Outline your commission. Make sure it's clear and not ambiguous.
Yeah, and unfortunately, I wish that the commission, and I'm probably speaking out of turn here, but I wish that the commission was just one number and it stayed static within. But there are some considerations sometimes that are made. So it usually is an underline that you personally have to fill back in. But the commission is so important. And at the beginning of the rental management agreement, it usually is our first or second clause there. And really to make sure too, to expand on it a little bit more, that the commission is based on base rent. It's calculated on base rent. So don't include it with all of your fees, right? So outlining some of that information is extremely important so that, again, you can manage owner expectation of what their return is going to be when they see their statements.
Talk about those extra fees. In the state of North Carolina, I'm actually required to outline to my property owners how I make money, not just with commission and maybe fees that I might attach to the rental, but any corollary or ancillary fees I might gain have to be in that agreement to inform my client. In North Carolina, we talk about clients and customers. The guest is the customer because they're not represented, but I am representing the owner. I have a fiduciary responsibility to that person or entity, and I need to outline to them, for instance, if I make a commission on travel insurance, if I have a relationship with an equipment company and they might give me some Benny on the end, all that is supposed to be in there.
Yeah, and even if you're in a state where that isn't necessarily required, it is important to list out what your fees are. And so that, again, you outline what is the base rent, what's commission, and what are overall fees that your company includes.
And we speak about the mentioning of fees and collection of monies, interest-bearing trust accounts. Those of you who have trust accounts, make sure you have a clause in there that indicates any interest is payable to the agent. You need to inform your owner, yes, I'm going to make interest on this, and no, it's not yours.
That is so good. That's so good.
It took me a minute to think of that one. We cut a little bit out there as the train left the station. But you want to outline the commission is item number 2, how you're going to get paid. Number 3 on our list here, Tiffany, of our 6 top that you want to have in your management agreement is making sure you have the term of the agreement. What do you mean there?
Yeah, so how long from the time that an owner notifies you to when the property would actually come off of the program. So I will say that throughout our businesses, it's not quite as consistent. Some of them are 60 days written notification. Some of them are 90-day written notification. Part of that has to do with some of our homes that are in an area or in a state that allows 31 days, so we'll rent not just nightly, but that 31 days, which is no longer considered short term. So we do have that 90-day for some of those, but it's important. How is the owner expected to communicate with you? We like certified mail. We like to make it a little bit more difficult, but also to make sure that we have all of our documentation in place. So how long before they, from notifying you and then coming off the program, and then how are they going to communicate that with you? And then how are you honoring those bookings or transferring those bookings? And who's responsible for the cost of moving guests? Sometimes you need to make sure that you have something in there that maybe it's their responsibility to pay for those costs.
I think what you're alluding to also is the cancellation of that agreement. I know nobody has ever had an owner cancel an agreement on you, but believe me, it does happen. And then what happens in that scenario? So I have noticed, I'll say competitive firms, at least in this area and the areas I work with, have gotten much more aggressive on this. If you do not cancel by this date, it automatically renews for another 2 years. And if you cancel in this time, it's going to be X amount, which sometimes it's 5-figure penalty for property owners to cancel the agreement. So this is really important stuff.
Yeah, well, and Tim, if you go to a couple episodes back, we talk about reading your contracts. I wouldn't be surprised if many of the suppliers that the listeners have agreements with have similar aggressive clauses like that. So I think we're at a state where you can put that. You've put significant investment into these properties, marketing them and getting reservations. And, you need to be able to manage what that loss would be to your business and outline something appropriate for this rental management agreement.
Agreed 100%. I had a meeting with a significant person in this industry this morning, and we were talking about this very subject. And the conversation rolled around to the point where if an owner gets to a point that they're going to cancel an agreement, do you really want to have an adversarial relationship with a property owner over the next 2 years? It just doesn't make a lot of sense to me. I've always had a very liberal cancellation agreement. And if you don't want to do business with me, fine. Just give me proper notice. I'm going to take payment on whatever I've done for you, and we're going to move on. I'm going to wish you well. I'm also going to keep that bridge open if it doesn't work out with that greener pasture across the way. I just don't understand why people are so punitive in this area.
Yeah, I will say though, I feel a little bit more punitive based on a year. So if they're, again, if they're managing expectations, which is going to be my word of this podcast.
Yes.
But a lot of owners come in, especially at this time frame in our, snapshot of our industry. A lot of our owners have paid high amounts. There's increasing costs. Some of the occupancy is a little bit different. Demand is a little bit different. And I've seen a lot of owners expect when they come onto a program to hit whatever their realtor told them that they would hit within the first year. And, if they get a little nervous, then they're immediately thinking, let me jump ship because this market must be so saturated. There's someone else that's offering maybe a 10% management fee, which is ridiculous. But you see a lot of that happen. And so I like to put a really aggressive language of if someone were to leave before a year, and they would have to return all of those costs associated back to me.
Because when you bring a property on board as a manager, you're not thinking about making a profit on that immediately, right? It's a long-term scenario. I think I heard some statistics. The average property owner stays with a property management company approximately 7 years. A lot can happen in 7 years. They might change their whole family dynamic. Maybe they don't want the beach house anymore, or whatever the case might be. But that first year, you're pretty much breaking even at best when you consider all the costs involved with getting that property on board. So I follow you there. No problem at all.
Yeah. And not to say that most people will do that. Again, it's just putting out there that they then understand that it takes more than just a year to get it going and marketing and branding and understanding that home.
Right. And you get those owners that seem to have, they've had 5 property management companies in the past 5 years. And you look at that and go, well, there's probably a reason why you haven't attained the earnings that you hope. You haven't gotten any traction. In that first year, a lot of times you have to cool your jets now. It's going to take a while to build our inventory here and of guests, and you need to be patient with us. But down the road, we're going to be doing well. And they're like, so-and-so says they can get me such and such. Okay, well, you're going to be number 6 in 6 years, if that's the case, right? Good luck on that. Okay. So term of agreement, not only the term of the time in which you will manage the property, but the term at the end is covered on that. So make sure that's in your agreement and it's very clear and unambiguous. That's my word for this.
And I should mention, because I went straight to negative, which tends to be my personality.
Yeah.
Making sure that what your renewal is, right? That you don't have to contact them every time for a renewal. So it's that evergreen contract.
Yep. Number 4 on your list is a special one for me, and that's maintenance cost threshold. Talk to us about that.
Yeah. So you have to outline a minimum amount to coordinate and schedule repairs without owner approval. We all have those owners that, depending on how they look at this investment, whether they answer the phone regularly or whether they don't. And so if you have an owner that you have to call all the time for a $200, maintenance labor charge to, get a new refrigerator handle, that's going to be a problem. So making sure that you have that set amount in there. And I will tell you, this is fresh for us. I have one company that we're sending new rental management agreements out because we just had to up our maintenance amount because we hadn't done it in several years and labor has significantly gone up and our team was having to make so many calls that were unnecessary and our owners didn't want to take those calls. So this is really important for you to include.
Yeah, air conditioner goes out on July the 4th and you can't get a hold of the owner. You need some sort of a limited power of attorney to act on their behalf in their best interest to replace the darn air conditioner because, by the way, Mr. Owner, you're going to be refunding that guest for every day that we don't get this air conditioner fixed, right? That's a real life scenario. I know you want to talk about some other things on this, but it also goes in another area for me in certain states, North Carolina. We advance rent to our property owners. Here on the Outer Banks, it's a very unique scenario. I pay my owners every month. So if I've booked something in the last week here, end of February, let's say we booked something for July, I would have paid that owner on March 1st, yesterday. And so the account balances. How much money do you have in your account? Do you have a minimum account balance? And then what do you do when a bill comes in because you cannot get into a deficit spending scenario? Do you have a $300 balance? Do you have a $500 balance? Do you have a $1,000 or $2,000 balance? Make sure whatever it is you have that you put language in there that puts the owner on notice. I can't overspend. I can't just take money from owner B to pay bills for you, sir. That's a violation of law. And so what do you have in your agreement? Do you have a penalty if the owner overdraws? Or do you have some system in place that they're going to be informed that they need to replenish funds right away? This is a critically important scenario for those of us in this game. It makes it very complicated on the accounting side. So those of you that don't understand this, I'd recommend not to dive into this as a business model. It's very difficult to manage, but it's sort of a requirement in this area. And it has presented a whole cadre of issues for us over time.
Yeah, but anyone who's listening who may not be in one of those states or specifically North Carolina, you really shouldn't be using any of that money ahead of time for, reserves. So get your accounting together.
What else on the maintenance, this whole threshold thing, making sure we're protecting the assets of the property owner and doing that in an informative way? What else should we have in our agreement?
So I really like to, again, I mentioned, but referencing back to a state statute or local ordinance, but state statute will have some type of habitability, right? Or standards. So you need to have reference to what your company's standards, or that, you can make those power of attorney decisions, right? So for some type of emergencies, or there needs to be some type of change to the property to meet your standards. And then also some type of language about habitability, right? So if an AC goes out, I know it's expensive, but there's an expectation during the summer to be able to have cool air within a home and not be sitting in 98-degree master bedroom. So having some of that specific language in your agreement is strong, and it will help you in those conversations with an owner saying, well, we wanted to take the liability away from you and we had to make these decisions.
Yeah, I think we've alluded to it, but haven't said it directly. You should have something in there that says it is the responsibility of the property owner to make refunds in that scenario. It's not my air conditioning that broke, sir. I had talked to a guy yesterday, and I'm going to use this analogy. I thought it was great. So we had a scenario where a glass top stove broke, right? Of course, some of you are cringing. Oh, glass top stove. Oh no, But the person made the analogy to the property owners they were speaking to them. They said, sir, it's as if you have a restaurant and you've hired me as your executive chef, and I'm bringing these customers in, and the customers dropped a wine glass or a plate and it broke. Are you going to make the executive chef pay for that? No, you as the restaurant owner are going to pay for that. And of course, this will be the most entertaining part of the story. In typical owner fashion, I'm sure some of you have dealt with owners like this. The owner responded, well, I have plenty of plates. Completely missed the point. They were responsible for the breakage of the stove because you shouldn't have had it there in the first place, for God's sakes. Come on.
Yeah, this is why we have each other, because half the time it's just a support group.
I know, exactly.
Those are never the responses I'm believe that I'm going to receive or know how to respond to.
Yes. So as we continue on our little session here of our mental health, I actually already covered this because I don't read scripts very well. Item number 5 is make sure your agreement's an exclusive management agreement. I think we already covered that. Okay. So now we can get into the real counseling, the real stuff that we've dealt with. And that's other, right? Miscellaneous, or as you put it, save your butt clauses that you can put in your management agreement. Let's get into some of those tips.
Yes, just save it. All right. We're doing you a favor here. Again, we are not attorneys, but you got to have an indemnity clause. You got to make sure that that's included. If you have your attorney, they'll make sure that they have it too. But in terms of liability, lost expenses, who's covering attorney fees, etc., that needs to be included. And I'll also say, who's responsible for obtaining licenses and permits? So you may, on behalf of the owner, submit permits, work on their behalf on getting inspections done if your area requires it. But at the end of the day, the permit or the license sits with the owner. So if you're having a new owner come on, you need to make sure that it's outlined whose responsibility it is to make sure they have that in place.
Great tip. I had a podcast a few years ago with another host who talked about that very thing and how it was assumed that the property management company would be doing the permits. And sure enough, there was a property, didn't get re-permitted, and there was all kinds of back and forth. Well, you were supposed to, no, it's your house. Well, you told me you were going to, oh my gosh, just not good. Not good at all. So excellent. And that's, if it's not in your area now, trust me, it's coming.
Yeah, just put it in there.
Yeah. So you talk about indemnity clauses. I would also add additional insured on the liability policy for the property owner. So if something comes up, you're covered. Because as I was told by my insurance agent when I looked for coverage, some sort of a liability coverage for all my properties that would cover me in case something happened, Tim, that's as though you have 300 office locations. And we're not insuring 300 office locations. You need to go back to your owner. And I know what you're saying, insurance agents don't want to do this, but they will if you insist. It's usually like $100 rider. and you can be named as an additional insured on that liability policy for that property owner's home.
That's a great one. And here's another one that I would say underline exclamation point. We've mentioned this before in one of our previous episodes, but there are no guarantees. I am a big believer that we do not guarantee a rental income. And I want to make sure that that's listed in there. There are no guarantees.
Good one. Yeah, I think some of us learned the hard way about that over time. And when we talk about losing a property, many times it's somebody who has just guaranteed me that I will get X amount of dollars. Well, good luck on that. So hey, have a little more confidence than I do. I'm not in the income guarantee business. Another one I have on my list is forum selection. I have it in my lease agreement with my guests. Probably also a good idea to put it in your owner agreement. I know you're never going to have a litigious action against your property owners. But if you do, you don't want to go to Pittsburgh to defend yourself or be the plaintiff, if you will. So that forum selection is as if it's taking place wherever your office is, in whatever county or parish it is in, that is where the grievance will be held. Again, pro tip, experience talking here.
That's a huge pro tip. And I've seen a lot of rental management agreements, and that is usually not included. So that good thing y'all waited till the end for that one. I've actually got a really fun one that I love and enjoy, and it doesn't work out for all of our locations, but for the ones that we have, it's one of my absolute favorite. But we have a marketing clause in there that we're able to use the property for 2 complimentary days. And during that time, we can use it for marketing. So if we have influencers that come in, or a lot of times you get asked for charity events, but the charity event as an opportunity for you to market that property. And so having those and having it stipulated that when you use it not during a high season time frame, it's really beneficial. And you also get a lot of great content for your homes.
Exactly. You wouldn't do it during a peak season, obviously, and you would do it only for the promotion of something. And so that is great. And you also might want to put language in there that you will take all responsibility for cleaning the property. It's not going to cost the owner anything other than maybe utilities for a couple of days. So that's great. I think another one on this extra items is what happens if there's a natural disaster. Nobody wants to think about it, but it probably is a good idea to put something in your agreement about that too, isn't it, Tiffany?
Absolutely. Acts of God, natural disasters. Look at what we had for COVID. What does that mean? Who's responsible? What responsibilities get taken off of the agreement? How do you survive? Need to make sure you outline some of that out.
Very good. You might also put something in your agreement about rate decision. Are you completely responsible for the rate? Do you have to go back to the owner for any rate changes? Or is there a scale in which you can change the rate up or down without their approval? Probably a good thing to think about if you haven't already.
Yeah, that's really good, because once you get those owners in there who are very specific about their rates or watch it constantly, it's a lot of hand holding.
I'm trying to think of other things I've had in my agreement over time. How about houses that don't normally accept pets, but the property owner has a Shih Tzu that sheds? That's a problem. They need to either accept pets and bring their own, or if they don't accept pets, they need to make sure they don't bring theirs, because people have serious allergies about this stuff, and it can be a real problem.
Tim, listen, we could go on this all day, because that just made it too. Again, talking about responsibilities, outlining when, you're responsible to have how many deep cleans a year, going back into those standards. So manage expectations, because I don't think I said it enough, but have that outlined as well.
I think what we're setting up here is maybe an onboarding episode of our property owners and how to show your owners love and making sure that relationship is such that you will never have to worry about many of these things we've talked about today. So that may be coming soon. All right. What else did we miss?
I don't know what we missed, but I would ask again that if you have, or if you're thinking of anything, let us know, because we just haven't lived through the trauma of it yet. And so we'll share your burden and protect ourselves in the future if you're willing to share.
Great. Okay, that pretty much does it for this episode. We'll be back soon. It will be daylight saving time by that time. Spring will be in the air. I will not be wearing black, as those of you on YouTube watching, but I hope you'll be with me. Black nails is the case, maybe, if you're looking. So it expresses our mood on a gloomy March morning here as we go along. But we look forward to seeing you again. Please, if you're on YouTube, look down there. There's a thumbs up. Give us a thumbs up. Or if you're on one of the apps that you watch us or listen to us, Spotify or Apple Podcasts, go over there and give us a 5-star rating. Really appreciate that. And we want to hear from you. I gave you the email address before, but you can hit us on social media, LinkedIn, and all those other places. So we really appreciate you listening, whether you're in Bora Bora or Bonanza, Nevada. We see you, and we really appreciate you taking the time to listen to our counseling session.
Until next time, y'all.
So long, everybody.